Welcome to the Insolvency and Law podcast, providing specialist insolvency and debt-related advice for business owners and individuals. For more information on debt recovery, business restructuring, and personal and corporate insolvency, visit our website www.insolvencyandlaw.co.uk or call us now on 020 7504 1300.
Hello, and welcome to the Insolvency and Law Business Advice Show, the podcast dedicated to debt recovery, credit management, and insolvency issues in England and Wales. In today's episode, we'll be focusing on two subjects: creditors' meetings and creditors' committees. If a company that owes you money has entered into a statutory insolvency procedure, such as liquidation, a CVA, or administration, keep listening, as you'll learn how to protect your interests and get back as much as possible. This podcast summarizes the benefits of creditors' meetings and creditors' committees for unsecured creditors in formal insolvencies. For more information, download the free reports from the Resource Centre at insolvencyandlaw.co.uk and purchase The Beginner's Guide to Debt Recovery by Insolvency and Law Director, Peter Murray. So, first of all, what is a creditor, and what is a creditor's meeting? A creditor's meeting usually takes place between 1 and 10 weeks after a company declares insolvency. Creditors are all the businesses the insolvent company owes money to. Generally speaking, there are two types of creditor. The first type of creditor avoids creditors' meetings because they don't think they'll get much money back. The second type stays away because they neither understand the insolvency procedure nor their own rights and powers. Most creditors assume they've lost all their money when a company enters a formal insolvency procedure. Very few realize they can assert greater control and improve their dividend prospects simply by requesting a physical meeting of creditors and establishing a creditors' committee. Usually, the process starts when an insolvency practitioner notifies creditors of a formal insolvency procedure. Upon receipt of this notification, you should immediately engage with other creditors, try to form one large group, and request a physical creditors' meeting. As individuals, creditors are powerless and disenfranchised, which is why it's essential they unite. But you must act swiftly, because if creditors take longer than 5 business days to request a physical meeting, they are deemed to have automatically approved the insolvency practitioner's appointment and fees. Physical meetings are an important part of the insolvency process because they keep creditors informed and provide an opportunity for them to communicate and understand their situation before casting their votes on how to move forward. Because there is no legislation relating to payment for insolvency practitioners, sometimes they try to discourage creditors by charging excessive fees to hold creditors' meetings. Nevertheless, a clever creditor who understands the process will push for a physical meeting and the formation of a creditors' committee. A creditors' committee consists of 3 to 5 people who are responsible for setting the insolvency practitioner's fees. As individuals, creditors have very little control over the insolvency practitioner or their work. However, creditors in a creditors' committee get to supervise the insolvency practitioner's transactions and determine their pay. In the vast majority of cases, insolvency practitioners are appointed by the directors of the insolvent company. However, here at Insolvency and Law, we believe that creditors should get to choose the insolvency practitioner. If they are unhappy, and 50% of voters in value and attendance agree, creditors may remove the incumbent insolvency practitioner and appoint their own. This is a good idea because creditor-appointed insolvency practitioners tend to be more transparent, pay higher dividends, and investigate company directors more thoroughly. Insolvency and Law can take instructions and attend creditors' meetings on your behalf. In many cases, we connect with other creditors to generate significant support before a creditors' meeting, because strength can be found in numbers. Sadly, we're coming to the end of this episode. But don't worry, if you need more guidance on creditors' meetings and committees, there are 3 simple things you can do. 1. Call Insolvency and Law now, on 0207 504 1300 and speak with a business rescue specialist. 2. Download the free reports on creditors' meetings and committees from the Resource Centre at insolvencyandlaw.co.uk. And 3. Purchase a copy of The Beginner's Guide to Debt Recovery, the latest book by Insolvency and Law Director Peter Murray, available from Amazon and all leading book retailers. Thanks for listening to the end of this podcast. Until next time, farewell.
Thank you for listening to the Insolvency and Law podcast. If you require additional guidance on any of the topics we covered today, visit the Resource Centre at our website, www.insolvencyandlaw.co.uk, or call us now on 020 7504 1300.